Sometimes, in certain cases, a claim may be mediated or arbitrated, rather than proceeding to trial before a judge or jury. Mediators and arbitrators are usually retired judges or attorneys with significant experience in the type of case they are hearing. Mediation is typically a non-binding process in which the mediator works to settle the case by reviewing the case independently and then persuading the parties to negotiate a resolution. The process is informal and non-adversarial. It requires your attendance and the attendance of the insurance representative, the decision makers in the case. The session is usually conducted in a conference room. A written summary of the case is presented to the mediator by each side in advance of the mediation, so medical records, photos, accident reports, even deposition testimony can be submitted so the mediator is completely familiar with the case before the mediation even begins. You will not have to testify, but will have the opportunity to speak to the mediator confidentially and with your attorney present about any thoughts and concerns you have. It's important to understand that the mediator cannot require a party to reduce its demand or increase its offer. At most, he or she can make a recommendation that neither side is bound to follow. If the case is not settled at mediation, the case would then simply continue through the normal course of the lawsuit. In arbitration, however, the arbitrator acts as a judge and makes an award based on the evidence presented. If damages are awarded, the arbitrator will determine the amount. Arbitrations can be binding, where the arbitrator's award is final and there are generally no rights to appeal, or they can be non-binding, where either side can reject the award and proceed to trial. It is critical that your attorney explain the type and terms of arbitration in your particular case. The arbitration is also usually held in a conference room. It's more formal than a mediation, but less formal than a bench or jury trial. You and other witnesses will testify under oath. You will be subject to cross-examination by the other side. Typically, the formal rules of evidence are relaxed. Both mediation and arbitration are alternative methods to resolve a case rather than going to trial. The attorneys at Salvey & Maher will always seek out the smartest and most efficient way to present and win your case. To discuss what option is best for your personal injury case, contact us today for a free, no-obligation consultation.